I call this meeting to order. Welcome to meeting number 34, the House of Commons Standing Committee on Justice and Human Rights. Pursuant to Standing Order 108, Sub 2, and the motion adopted on September 22nd, the committee is meeting to begin its study of the subject matter of Bill C-28, an act to amend the Criminal Code, self-induced extreme intoxication. Today's meeting is taking place in hybrid format, pursuant to House Order of June 23rd, 2022. Members are attending in person in the room and remotely using the Zoom application. I'd like to take a few moments for the benefit of the witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you're not speaking. Interpretation for those on Zoom, you have the choice at the bottom of your screen of either English, Floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed to the chair. For members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raise hand function. The clerk and I will manage the speaking order as best we can, and we appreciate your patience and understanding in this regards. I'd also like to inform the members that all tests involving the witnesses have been performed successfully. And also, I use a little cue card system. When you've got 30 seconds left, I'll raise the yellow card, and when you're out of time, the red. And I ask that you conclude it in that time so I don't have to interrupt you, as I don't want to wreck the flow of your conversation. I'd also now like to welcome our witnesses appearing today. We have Elizabeth Sheehy, a professor emerita of law, University of Ottawa, and we have Carrie Frock, associate professor, University of New Brunswick, and I believe we have Isabel Grant. She's there? Okay. Oh, there she is. She just turned on her screen. Yes, I'm here. By video conference for the first hour. So you each have 5 minutes. Oh, first of all, welcome to the committee, and you each have 5 minutes, and then afterwards we'll have subsequent rounds of questions. So we'll begin by Ms. Sheehy for you, 5 minutes, or whichever, your choice.
Mr. Chair, if it's all right, I would like to begin first. Good afternoon, Honourable Chair and members of the committee. My name is Dr. Carrie Frock, and I'm an associate professor at the Faculty of Law at the University of New Brunswick. And my area of research is constitutional law, and I specialize in women's rights. Both Professors Sheehy and Grant are national and internationally recognized experts and authors on violence against women and criminal law, particularly in relation to sexual assault. And I would urge you to give what they have to say about the knock-on effects of Section 33.1's onerous burden on the Crown and how to fix it very serious attention. I am the chair of the National Association of Women and the Law, but I am here in my personal capacity. However, if you have factual questions in relation to the lack of consultation before Bill C-28 was introduced, and to be clear, the consultation with NAL was a sham, I can answer them because I was there. However, if you take nothing else away from my presentation, I want you to hear this. Parliament has other options than simply to legislate in identical words to those used by the Supreme Court in Brown. The court has recognized that Parliament is a constitutional interpreter in its own right and that its interpretations are worthy of respect. Indeed, in Brown, it recognized that its suggestions were simply that, suggestions, and that Parliament will be afforded deference when it comes up with a fix. It did not guarantee that if Parliament followed either of its two suggestions, it would be charter-proof, nor did it maintain that Parliament must follow one of its suggestions using identical words to describe the threshold fault standard for the amendment to be constitutionally sound. When the Supreme Court declares a piece of legislation unconstitutional, the response is usually, as it was here, for Parliament to go back to the drawing board to address its objective in a constitutional way, using the court's ruling as guidance. When the court analyzes second try legislation, it gives due deference to Parliament's attempt to solve a complex social problem in a way that respects individuals' rights. This does not mean that Parliament has carte blanche to violate rights on a second try, but it does mean that the court respects the separation of powers. Parliament is engaged in a process where all stakeholders are heard. The government attempts to reconcile disparate interests for the collective good, and democratic representatives, you all, deliberate. Ideally, that's how it works. Courts are confined to the parties before them and the legal issues brought forward by these parties, sometimes perhaps guided by interveners. They interpret the Constitution and apply it. That's all. So in Brown, Justice Castillo said, "I am aware that Parliament is entitled to deference in this analysis. Indeed, in crafting a new legislative response to the problem of intoxicated violence, it is up to Parliament to decide how to balance its objectives while respecting charter rights so much as possible." He also said, "I am mindful that it is not the role of the courts to set social policy, much less draft legislation for Parliament, as courts are not institutionally designed for these tasks." Now, the court said in relation to amending Section 33.1, one academic, Hugues Perron, which I understand you'll be hearing from, proposed no less than 4 variations in how to satisfy the minimum criminal standard. Justice Kassirer also called the standalone offense of criminal intoxication not a viable alternative in terms of achieving Parliament's objectives. Therefore, the 2 options mantra that you've heard over and over is a mischaracterization in more ways than one. Last, I want to suggest that there might be very good reasons for Parliament not to abdicate its role in legislating and give it over to the Supreme Court. Contrary to its own jurisprudence, the Supreme Court did not give women's rights consideration in the constitutional analysis, at least not due consideration and equal consideration. And Professor Sheehy and my paper, which we provided to the clerk in advance of the hearing today, and which I hope that you'll have the opportunity to read, provides this critique in detail, and I can explain it or elaborate upon it today. I know that ensuring that women's rights are given at least as much consideration as the rights of accused persons is very much in keeping with the tenor of your questions and discussions on the bill to date. Professor Grant's recommendations do just that while adhering to the court's guidance in Brown. And I understand that she's under some time constraints, so it may be that you decide to direct the first round of your questions to her, but I leave that to you. So thank you very much.
Thank you, Ms. Frock. Over to you.
Good afternoon, and thank you for inviting me to speak on the amendment to Criminal Code Provision Section 33.1. My main point is that the defense of extreme intoxication will be invoked most frequently for crimes of male violence against women, with consequential effects for the reporting, policing, and prosecution of these crimes. And if you examine the evidence in Brown and Chan as examples, you'll see that the new law will be largely incapable of limiting the extreme intoxication defense. In the 12 months between the release of Davio and the enactment of the original Section 33.1, the defense was advanced at least 30 times in reported cases, and they represent the tip of the iceberg. Almost half, 12 of these cases, involved clear violence against women, 6 sexual assaults, 5 spousal assaults, the murder of a woman in the sex trade. Another 2 involved attacks on women. 1 man brutally beat his mother. Another attacked a woman in a nightclub. The majority of these claims were rejected for want of proof, but of the 6 cases where the defense succeeded, 4 were spousal assault cases. Advocates on behalf of women who experience men's violence readily understood that the extreme intoxication defense seamlessly colludes with narratives around violence against women that suggest that it is never men's fault, but rather women's fault, or somehow an agentless crime that is simply an inevitable feature of life. Had Section 33.1 not been enacted in 1995, we might have seen at least 30 reported cases a year of attempts to use this defense. And over 26 years, that would have been a minimum of 780 cases. The original Section 33.1 put a near halt to this defense. But even so, in that 26-year period, we found 86 cases where Section 33.1 was mentioned, either to consider its constitutionality or at least as one reason for rejecting an intoxication defense. While one author reports that only 4 could have succeeded because most failed the Davio proof standard, that doesn't account for the fact that Section 33.1 barred the defense, such that lawyers could hardly have been expected to invest in the resources required to both launch a constitutional challenge and substantiate the defense with expert evidence. Of the 86 cases, 35 involve sexual assault. Another 5 involve men who attacked their current or former partners. And beyond those 40 cases of clear violence against women, there were another 23 cases where women were victimized, either as the sole target of the accused's violence or as another victim in addition to male victims. Altogether, 63 of 86 cases involved female victims. 80 of the perpetrators were men and 6 were women. These numbers bear up even in the 3 cases before the Supreme Court of Canada in Brown, Sullivan, and Chan. 3 male perpetrators, 3 female victims, 1 male victim. Although we cannot predict how often the extreme intoxication defense will succeed, the harms to women extend to men's attempts to invoke this defense. There's a serious risk that women will be deterred from reporting these crimes where perpetrators are intoxicated because they will not be in a position to assess whether an extremely out-of-it perpetrator can be held accountable. Further, the trauma caused to complainants by lengthened trials based on the extreme intoxication defense being advanced, the resulting diminished confidence of women in the justice system, as well as the wasted judicial and Crown resources, all must be considered as negative implications of this now unleashed defense. Police and prosecutors will need to account for the extreme intoxication defense in their charging and prosecutorial decisions. It may also have an impact on cases involving lower levels of intoxication. Of course, currently, anything short of extreme intoxication is no defense to crimes of general intent like sexual assault and manslaughter. But when the Crown or police are deciding whether to lay charges, they do not know exactly how intoxicated the accused was. They may not have solid evidence about whether that intoxication crossed the line to extreme intoxication. That evidence is uniquely in the hands of the accused. The Crown has no access to it unless they were able to test his blood immediately after the occurrence, which is rare. They know that these trials are going to require expert evidence and be resource intensive. This could lead to them not laying charges where a high level of intoxication is involved, particularly in provinces like BC, where the charge approval standard is substantial likelihood of conviction. In turn, we will have no way to track the impact of the extreme intoxication defense on crimes of violence against women. Thank you.
Thank you, Professor Sheehy. Next to Professor Grant from UBC.
Thank you very much, and thank you for giving me an opportunity to speak to you today. I've been a criminal law professor for 35 years. My research was cited by the Court of Appeal of Alberta and the Supreme Court of Canada in Brown, and I was retained many years ago by the Department of Justice to examine the question of whether Parliament could constitutionally limit the defense of extreme intoxication for crimes of violence against women and girls. I believe that the response to Brown that you have before you in Section 33.1 was ill-conceived and rushed. And as Professor Sheehy has explained, I'm worried that it will have effects beyond cases of extreme intoxication. I think the lack of concern we've heard from the defense bar about this legislation gives us a signal about how effective it will be in protecting women and girls from male violence. I'd like to raise a couple of problems specifically with Section 33.1 and suggest to you that there are some pretty easy fixes. The first problem is that the legislation missed the opportunity to codify Davio and to say that the burden of proof is on the accused when he is raising a defense of extreme intoxication. Now, I hope that most judges will assume this and read it in, but it was an oversight not to codify that in section 33.1. But the bigger problem is the standard in section 33.1 subsection 2. You have the legislation before you. Subsection 1 sets out the test that the Crown has to prove, the marked departure test. That is a constitutional minimum from which we cannot depart because the Supreme Court of Canada has indicated that. But subsection 2 really complicates the situation. Subsection 2 says that a judge must consider the objective foreseeability of the risk that the consumption of intoxicating substances could cause extreme intoxication and lead the person to harm another person. Now, it's not entirely clear what this means. What does it mean that a judge has to consider a legal standard? What if the judge considers it? Is the judge free to reject it? Is it determinative of the issue? It's a confusing standard for courts to apply, and it's not clear to me why it's even necessary or helpful. But the bigger problem with section 33.1 subsection 2 is that the standard of objective foreseeability of the risk of harm is unprovable by the Crown. And what that means, of course, is that there won't be any cases in which this defense is denied. In other words, that section 33.1 is not putting a limit on extreme intoxication. And the reason it's unprovable is because extreme intoxication is more likely to lead to unconsciousness or sleep or some other response on behalf of the accused. Violence is not a common response to extreme intoxication. And what that means is an accused can always say, well, I've been intoxicated before and I wasn't violent then, so how could I have foreseen that I would be violent this time? Or I've never been extremely intoxicated before, so how could I possibly have foreseen that this time it would lead to violence? When you're dealing with relatively rare events, having a standard of objective foreseeability of harm is completely unworkable. So unless you have an accused who's consumed the same amount of drugs and alcohol in the same circumstances and committed violence in the past, it's almost never going to be reasonably foreseeable that harm to another person would result. Now, as I mentioned earlier, I think there are some easy fixes to this. The simplest one is just get rid of subsection 2. It isn't necessary. It's confusing for judges. It's telling them how to do their job. Judges apply the marked departure standard all the time. They know from case law that they have to look at all the circumstances of the offense and the circumstances in which that offense took place. Judges don't need Parliament telling them that they have to consider another legal standard. Maybe that's different than applying it, but that they have to consider it and without saying what that actually means. So the simplest response would be get rid of subsection 2. It's confusing. It could result in 33.1 being completely useless. A second option, though, if you think it's important to retain subsection 2, would be to change the foreseeability standard and require foreseeability of a loss of control over one's actions instead of foreseeability of harm. Because as I said, when you're dealing with foreseeability of what is...
Sorry, your time is up, but hopefully you will be able to extract...
Yeah, no, sorry, I didn't see the warning,
No.
So maybe we could pursue this in questioning. Thank
Sure.
you.
Thank you. We'll go to our first round of questioning to Mr. Moore for 6 minutes.
Well, thank you, and thank you to all of our witnesses. Really appreciate the input that you're giving today. Professor Grant, you were just finishing a thought. Now, I only have 6 minutes to work with, and I do have a number of questions I wanted to get to, but if you wanted to finish your thought, I'd give you the time to do that now.
Thank you very much. Very briefly, I was saying there are 3 ways to fix this problem. One is get rid of subsection 2. The second way would be to change the foreseeability standard to loss of self-control rather than foreseeability of harm. And the third option would be to insert a reverse onus clause that requires the accused to show whether or not the harm was foreseeable. That's been upheld as constitutional in Davio and in the context of the mental disorder defense as well. So those are the 3 options.
Thank you for that. And I guess this goes back to Dr. Frock, a comment that you made around consultations. To me, there's really no excuse to not have extensive consultations when we have serious decisions before the court. It's easy to contemplate that the court's going to make a decision and government has to respond. And some of these, if there's no suspension of invalidity, they can have immediate and wide-reaching consequences, as this situation did, and resulted in Bill C-28. I think the kind of discussion that we're having today and the kind of really detailed input that you've given, did you have the opportunity to provide that level of detail to the minister, to the department, as they were contemplating drafting a response to this decision?
Right, and I mean, we were consulted by a junior member of the Department of Justice on June 14th, and we provided a very detailed proposal to them by 5 p.m. that day. But of course, the first reading of Bill C-28 happened on June 17th, so the horse was already out of the barn at that point. It was just a lot of thank you for your input, but it was obvious that it wasn't taken into account in any way whatsoever. I don't know when other groups were consulted. That might be something that you want to ask them. But all I can tell you is that we were consulted within days before the bill was introduced, and we had another very brief consultation. I believe it was on June 17th. Luke Place was invited to a Department of Justice consultation. I had about 15 minutes notice that was happening, and I just so happened to be able to get on the call. But again, it was our suggestions were dismissed fairly summarily. But I can tell you that we provided a lot of technical detail on very short notice during that.
Yes, and now, I mean, speaking of the horse being out of the barn, now that we have legislation that is currently in place, but this study that we're doing is backwards. Normally, committees, we study bills and get the type of evidence we're getting from you now as the bill is proceeding through the House and then on to the Senate. This is reversing that order, so it presents challenges for us, but we want to make sure that we as parliamentarians, as you rightly illustrated, do our job, which is to draft legislation that's going to work. You mentioned, and all of our witnesses mentioned, the disproportionate impact on women, and we've seen that in these cases, and we've seen it when this defense is used. How do you respond to LEAF, the Women's Legal Education Action Fund? How do you respond to their support for C-28?
I think you'll be hearing from LEAF, so I think you can ask them those questions upon who they consulted for their analysis and upon what basis they made it. All I can tell you is what we did, and we, Professors Grant and Sheehy are before you. There's other people that we consulted, and I'm rather partial because Professor Sheehy was my master's supervisor, but I can tell you that that both of them were cited by the court in Brown. They have decades of experience, not only doing the analysis of criminal law and constitutional law, but they also are very well regarded in the women's community of organizations dealing with violence against women. So that's why I'm encouraging you. I'm a relative new professor in relation to them, but I would again just encourage you to listen to them very seriously.
Yes, and I have a bit of time, Chair. Yes, and that's exactly what we're doing here today. We're listening very intently to what you have to say. It's been described, and Professor Sheehy, maybe if you'd like to respond to this, but that Parliament was really given only two options with the Supreme Court decision. You could pick lane A or lane B, and there was reasons why lane A was picked and not lane B. You're saying that was a false choice, that there's other options. Do you want to just quickly respond to that?
I don't want to hog the microphone, but I can respond to that. And again, just to reiterate, the court said that lane A wasn't a viable option of creating a standalone defense. And the reason it wasn't a viable option is it said that the objectives of protecting women and girls and also, having accountability, enough accountability, it simply wasn't a viable alternative. So really what they were saying is that the only thing that would satisfy the objective of Parliament is amending 33.1. And it never said that you have to follow lockstep with its wording that it suggested for very good reasons, because it knows that Parliament can engage in the kinds of consultations that you're doing right now. What it did say is that it needs to be a minimum criminal standard, and there's a number of ways you can do that. Again, they cited one academic that said there's 4 ways. We've proposed other ways as well that we believe are constitutional. So again, it's up to you to make that assessment based on what we're telling you might be some of the effects of getting this wrong.
Unfortunately, you're out of time. We'll try to get it with someone else. Next, we have Mr. Nakvi for 6 minutes. Oh, Ms. Briard.
Thank you, Mr. Chair. Merci à tous les témoins d'être présents avec nous cet après-midi.
Thank you to all witnesses for being here this afternoon. I congratulate you for the work you're doing on constitutional law, particularly as pertains to women's rights. Bill C-28 was introduced in response to the Supreme Court decision in Rum, which invalidated 33.1 of the Criminal Code and thus set aside the extreme intoxication defense. Do you agree that in invalidating 33.1, the Supreme Court ruling left a vacuum in the bill, first of all? And secondly, don't you believe that Bill C-28 meets or has a good solution to the issue?
Can I respond to that just really briefly? Yes, Section 33, the decision in Brown definitely left a vacuum, but I don't know what defense this legislation will limit. I think that vacuum is just as serious today as it was before this legislation is drafted. I don't understand what hypothetical accused will be denied a defense under this legislation. I don't think it will happen, and that's why we're here today, because we're very worried about that.
Merci.
Thank you.
Well, I would certainly agree with Professor Grant's comment. And I guess that, we had a vacuum, we have a vacuum. I don't think that that justice is served by rushing a solution, because a bad solution is not going to, in fact, address the issue. So, I mean, I'm just repeating, I think, what Isabel's just said.
Dr. Frock?
Certainly. I think the point that both Professors Grant and Sheehy are making is you need to get this right, because the potential consequences of getting it wrong are very serious. And they're not only in terms of reported cases. We've told you that there's 86 reported cases, even most of them coming out after 33.1 was enacted. But it's also in relation to the charging decisions and the prosecutorial decisions. Some of those we will never see. And it'll be very difficult to know exactly what the implications are from leaving the defense so open.
Est-ce que vous êtes d'accord pour...
And you agree in saying that the fact that someone negligently or voluntarily puts him or herself in a difficult situation and is then able to escape the consequences if somebody is hurt as a result, are you saying that is unacceptable?
Well, I think what we're saying is that it's actually discriminatory to shift the burden of that harm onto the shoulders of women. I mean, you know, the individuals who've engaged in overconsumption of alcohol and drugs and who have, in consequence, caused very serious, sometimes life-altering injuries to other people, are able, under this defense, to shed all responsibility. And that's then left on the shoulders of women. And I guess what we're saying is that's discriminatory.
Thank you. Et justement, après la...
After the Brown decision, we saw that there was a great deal of misinformation, particularly online. Young women, for example, who genuinely believed that if they were assaulted, they would have no protection. Can you comment on that misinformation, please?
Can I respond to that? Or who? I'm
Yes,
not sure.
Professor Grant, go ahead. Sorry.
Yeah, I mean, I think clearly the example you give would be misinformation, but you've got to put yourself in the position of a busy Crown Counsel who's deciding whether to lay a charge, and a young woman comes forward and says she was sexually assaulted by a very intoxicated man. And that's all she knows. She doesn't know how much he consumed or what he consumed. Crown Counsel has to make a decision. Are we going to lay charges in that circumstance? I'm not sure that in many of these cases they will. We already know that sexual assault is vastly undercharged in this country. So I think what was overblown was the degree to which this was in fact misinformation. We don't know the impact of this decision, and we don't know how we're going to study it if the consequence is that charges are never laid in the first place.
Thank you. Dr. Frog, maybe?
Certainly. And, you know, in my past life, I was a practitioner in Saskatchewan, and it's kind of incomprehensible to me that the way that you counteract misinformation on social media is you enact amendments to a very complicated area of law. There are quite a few other ways that one can engage in public education, you know, and giving core funding to women's groups might be one of them, so that they can run their education campaigns. You don't do it by amending the criminal code.
Thank you, Madam Briard. Next to Monsieur Fortin for 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. I'd also like to thank the witnesses here today for their participation. As my colleague, Mr. Moore, was saying, it is unusual for us to be studying a bill after it has come into force, but we have had no choice. We have little time, as you will have seen. I'd like to use my 6 minute on paragraph 2 of 33.1. Ms. Frock, you talked about objective foreseeability. I'm going to be the devil's advocate, or play the devil's advocate in my, if I may, to decide if somebody has moved aside from due diligence. The court takes into account the objective foreseeability of risk that the consumption of intoxicating substances will lead to harm for another person. Objectively, when you take an intoxicating substance, isn't there objectively always a risk? We're not talking about whether at the time it was clear that the person would become extremely intoxicated. What we're saying is, was there a risk? And an objective assessment could be made of foreseeability. As I was reading this, I might have said as a court that when you consume an intoxicating substance, there is a foreseeable risk that this could cause harm or lead to harm for another person. I'd like to hear your view on this.
And I would defer to the Professors Sheehy and Grant on this. But one problem with that is that you have the Supreme Court in Brown using risk of harm and risk of extreme intoxication disjunctively. We're using it conjunctively here, where you're essentially saying that the Crown has to prove both. So that's one issue. The other issue is, and you've heard the Minister of Justice say that this is a contextual analysis in terms of what the objective foreseeability is. What does that mean? Does that mean someone in the shoes of the person that has consumed the intoxicants? Does that mean, as Professor Grant said, that if you've never become extremely intoxicated before, how could I have foreseen this? Or if I have? Objectively, but contextually objectively, and that's the problem. But I don't know, Professor Sheehy?
I would just add, all you have to do is look at the expert evidence in both Brown and Chan. I mean, in Brown, the trial judge decided that although Mr. Brown testified that he had consumed between 13 and 17 drinks and snacked on handfuls of magic mushrooms all evening, that it was unforeseeable that he would lose the power of self-control. We're not even talking about harming someone. So the cases before us demonstrate that this is going to be really difficult, actually, because the defense can get experts who are prepared to say that the person was in a state of extreme intoxication, but they're not prepared to say, or they feel they cannot say, that that was foreseeable, because they don't know exactly how much he consumed, they don't know what how much psilocybin was in that particular dose of magic mushrooms. They don't know what, the rate at which he consumed. They don't know his experience with drugs. So all these factors mean it's going to be very hard for the Crown to prove even foreseeability of loss of control.
Okay. Et
I understand, Ms. Frock, that you were saying one solution would be to eliminate paragraph 2 altogether. If we take the hypothesis that paragraph 2 is not eliminated, how can it be rewritten?
Well, I defer to Professor Grant on that because she's the expert on the reconstruction.
Yeah, and I was the person who suggested that you get rid of subsection 2 because it's not necessary. The standard that the Crown has to prove to remove the defense is already in subsection 1. Judges know that they have to consider the circumstances. I think a test that if you wanted to just change that standard, even foreseeability of a loss of control would be a more workable standard than a foreseeability of harm. Because where it is foreseeable that you will lose control of your actions, then you should bear the risk that those actions are going to seriously harm another person. That burden should not be placed on the victims, who are disproportionately women and girls.
Mais si on part du...
But if we start with the principle that the idea is to offer up an acceptable defense, a defense that works for crimes of this nature, and that we have no choice, we'll have to live with the possibility of a defense of an unforeseeable extreme intoxication. Should we at least not restrict the foreseeability as we're doing here, because without that restriction, either there's no possible defense for a voluntary extreme intoxication, and I might agree with that. I'm not taking a position. I'm just trying to reflect or to think about this objectively.
Merci, Monsieur le Président.
But the standard is in subsection 1. It is not in subsection 2.
Thank you. Next, to Mr. Garrison for 6 minutes.
Thanks very much, Mr. Chair, and I want to thank the witnesses for being here today and for the very valuable testimony. Certainly, part of the agreement to act quickly, for me, was contingent on holding these hearings. And so I think many of us around the table understood we were acting quickly and would not have agreed to taking that quick action without the guarantee we were coming back to look at this more carefully. And I think you're already demonstrating today why that was necessary. So on the question of the vacuum created, I just have one question, and that is, did it do anything to fill the vacuum by requiring the accused to prove they were in a state, or to provide expert evidence that they were in a state of extreme intoxication in order to try to avail themselves of this defense? Was that any sort of improvement?
I'll just say really
The
quickly.
Supreme Court of Canada did that in Davio many years ago. That's always been the case. The Crown simply cannot prove whether the accused was extremely intoxicated because it does not have access to what the accused consumed, how much, what it was, and we cannot compel an accused to provide that evidence to the state. So that was already done by Davio. Section 33.1 does not do that at all. And I think Section 33.1 does not narrow the vacuum in that regard.
Professor Shi, we're going to make similar remarks, I suspect. Please do.
Me repeat it?
Well,
Well, no. The new version of Section 33.1 doesn't add anything. The Supreme Court of Canada had already established that the burden of proof is on the accused on a balance of probabilities to prove that they were in this state of extreme intoxication. So the revised version doesn't add anything. And as Professor Grant pointed out, by not incorporating that Davio standard of proof into the new Section 33.1, there is a risk that some judges will drop that. So that was her first point in her presentation, that, gee, we might want to actually have that re-articulated in the section itself.
so if I'm understanding correctly, that section should have been maybe a bit more extensive in incorporating the Davio decision.
That was Professor Grant's point, yes. Yes. So there was no vacuum created with respect to that standard of proof by the Brown decision. But in the new version of the legislation, it might be wise to re-articulate that standard of proof.
Okay, and
that standard of proof was upheld as constitutional in Davio.
right. Okay. In the sort of hierarchy of fixes that you suggested, I guess my view of that is if we could act quickly in enacting C-28, we should be able to act quickly on any of these fixes. So that would be my hope. I guess, is there a hierarchy in those fixes, not just in terms of their simplicity, but in terms of their certainty for narrowing the defense? And any one of you, maybe Dr. Frock, you laid out those three. Maybe I can just ask you that.
As a matter of fact, it was Professor Grant, so I'll allow her to answer.
Okay.
Thanks. Yeah, I think I listed them in the order of preference. I think the simplest, but also the most effective, is to get rid of subsection 2. Judges know how to apply a marked departure standard. They've been doing it for decades in other criminal contexts, like criminal negligence. So my preference would be get rid of it altogether. The second choice would be to clarify what the standard is, but also to reiterate that the burden of proof in showing that something wasn't foreseeable should be on the accused and not on the Crown.
And the third would then be the least favorable, in your point of view, in
well, because the third would retain a standard that's unworkable, but it would shift the burden onto the accused. So I think the best thing to do is get rid of the standard. But if you want to keep the standard, it needs to be clear that the burden is on the accused to show why he couldn't possibly have foreseen the likelihood of harm. Making the Crown prove that beyond a reasonable doubt, it's impossible. That's a very, very high threshold to prove that beyond a reasonable doubt. That's what we do in the context of the mental disorder defense. An accused who's saying, I'm not responsible for a crime because I was mentally ill, has to prove it on a balance of probabilities. And I would say the same should apply here. And the courts have upheld that as constitutional in a case called Chalk and Morissette.
And on the question of what I guess I'll call the foreseeability standard, shifting that to loss of control rather than the foreseeability of harm, I guess Professor Grant again was arguing this, is that narrowing the ability to use the defense or simply clarifying?
I think it's narrowing it a little bit, not very much. I think the standard is problematic, and that's why I think either of the other options would probably be better. But I think it narrows the defense by allowing a chance that the Crown will be able to meet its burden and deny the defense to an accused in a particular case. I still think the Crown's going to have a lot of problems with any standard, given the things we've seen in cases like Davio and Chan and Sullivan, but I think it gives the Crown a bit of a better chance. But getting rid of it gives the Crown a better chance.
Thanks very much. I know I'm out of time at this point. I want to come back to the question of the problem of charging that exists in maybe the next round.
Thank you, Mr. Garrison. Now, for the next round, Mr. Caputo for 5 minutes.
Thank you. Thank you all three professors for being here. I was, I believe it was Professor Grant who talked about British Columbia. Everybody around this table knows, but I'll repeat it for the benefit of our witnesses. I was actually a prosecutor in British Columbia, and most of what I did was actually it was sexual offenses, mostly though sexual offenses against children. So for the benefit of our report writing, what generally happens is that in some jurisdictions, the police actually lay the charge, but in British Columbia, the charge comes through a report to Crown Counsel, and then a prosecutor will look at that, and they have to evaluate all defenses and whether a legal threshold is met, which is a substantial likelihood of conviction, which is actually quite high of a threshold. It's not just a likelihood. It's, probably around 90% is what most people would put it at. So if I understand your comments, particularly those of Professor Grant and Professor Sheehy, did I pronounce that correctly? Thank you. If I understand your comments, you're saying, how can a charge be laid in the circumstances because you don't know what might be around the proverbial legal corner when it comes to a defense? Do I have that correct?
Well, the complainant's own evidence. No, go ahead.
No, I was just going to say, unless you've been able to apprehend the accused immediately, do all the tests to ensure what his alcohol level was, what his drug level was, which is rarely the case in sexual assault, the Crown simply won't have the information as to how intoxicated the accused was at the time of the offense. It's just not going to be there. And given this legislation, meeting that substantial likelihood of conviction threshold is going to be very difficult in cases whenever the accused was very intoxicated, even where the standard of extreme intoxication might not necessarily be met.
Right, because this is information that is completely 100% in the hands of the accused.
Yes,
exactly. Right. So how can proof beyond a reasonable doubt occur when theoretically this defense could be raised after the Crown's case is in? Do you understand what you probably understand what I mean by that?
Yeah.
Yeah. Meaning, in other words, the Crown has put its full case in, and then the defense could raise this in its evidence without the Crown actually being aware. Does that accord with your understanding of how this might play out?
Yeah, I mean, I think my worry would be that that the complainant has told the Crown, well, he seemed really drunk, or he seemed out of it, or he seemed high, so that the Crown will have some indication that this is an issue, and that may impact charging decisions. So I'm less worried about the cases that make it to trial, because I think those are the more, I'm worried for the reasons I set out about the standard being unprovable. A woman may be put through a trial with no chance that the perpetrator is going to be convicted. But in terms of the impact on sexual assault more widely, I'm worried that the charge won't even be laid to begin with.
Worried that at the charge approval stage or at the consideration stage, there would be consideration being intoxication or extreme intoxication is a live issue here, and we may have proving beyond a reasonable doubt, not necessarily that there was an assault of a sexual nature, but proving beyond a reasonable doubt that this person wasn't so intoxicated as to negate the general intent of the offense.
Yes, because we know that if you're very drunk and you sexually assault someone, that's no defense in Canadian law. If you're very, very, very drunk and
Well, I pause here, and I believe that this was mentioned in Professor Frock's written comments. I may be mistaken, but the reality is that somebody who is in a state akin to automatism by virtue of alcohol, I don't know how they get to that point physically, in that a person who is that drunk to the state in a state of intoxication. Professor Frock, do you have a comment on that?
I do indeed. And the problem is that the Supreme Court of Canada in Brown specifically addressed that particular situation, and Professor Sheehy was a witness before the committee at the time after Davio, and we know very well that there's a number of experts that have come out to say that alcohol will very seldom get you to that stage, but the Supreme Court said we're not going to rule it out either. So that's one of the problems. The problem is when you get a combination of alcohol and other drugs as well, which is appearing in fair frequency in the cases that we've seen. And we invited as NOL to even put that, if it never happens, that it's only alcohol, why not put that right in 33.1? And that wasn't something taken up.
Appreciate your time. Thank you.
Mr. Caputo, we'll now go over to Ms. Dillon for 5 minutes.
Perfect. So my question will be to any and all of the witnesses. Can you outline to us the importance of being clear that simple intoxication is not a defense to a crime, which both the Supreme Court of Canada and the government have made clear?
Yes, that issue is not up for grabs. It's very clear that simple intoxication is not a defense to any of these crimes, not to the kinds of crimes we're talking about, general intent crimes. It is a defense to specific intent crimes like murder, for example, but it is not a defense for these crimes. The issue, however, is from the point of view of complainants or police or prosecutors is how to tell the difference. Are we dealing with a simply intoxicated person, or are we dealing with a person who was extremely intoxicated? And that's the difficult thing. That's a matter of expert evidence, and you're not going to know the answer to that until you actually have the expert witness before you, or witnesses.
And may I follow up with the next question? As you know, the onus is on the defendant to prove that they were in a state of automatism, but not the Crown or the victim. Could you please explain to us your thoughts on that?
Well, as Professor Grant has pointed out, it's entirely appropriate that the burden of proof be on the accused to prove on a balance of probabilities that they were in such a state. It's information and evidence in their hands, not the hands of the prosecution. And furthermore, it's not considered to be a normal state to be in that kind of state where the person is actually not operating with their body and mind together. And so we require that the accused be the one to bring forward the evidence to prove that they were in such an unusual state.
And how do you feel about the fact that with this bill, the prosecutor will have additional means of establishing the commission of the offense by establishing that the accused's voluntary extreme intoxication constituted criminal negligence?
Well, I think the difficulty with this legislation is that it suggests that the Crown has to prove foreseeability of loss of control and has to prove foreseeability of risk of harm. And I think that particularly the second standard is going to be impossible for the Crown to prove. They're going to have to prove it beyond a reasonable doubt. It's a very high standard of proof. The Crown's going to have to at least have 2 experts to counter the accused person's 2 experts. And I think that proving that a particular drug was likely to lead to violence is impossible. There are no studies, for example. There are no studies that demonstrate specific links between specific drugs and crimes of violence.
Would you have anything to add to that, Dr. Frock?
Well, you know, I've watched your questioning in other hearings, and I have reflected on it. And I saw, and I counted actually in the Supreme Court, and they said at least 2 or 3 times that mere intoxication is not a defense to assault and sexual assault. So in terms of using a complicated area of law to correct misinformation on Twitter or other social media, that is not on. So I would just implore you, particularly because there are these inadvertent effects that we're talking about that you will probably never see. It is going to be very difficult to collect data, for instance, on how many charges weren't laid or how many prosecutions weren't done, because a defense of extreme intoxication is in the offing. So you need to get this right now. And to say that we needed to act because of misinformation on Twitter, I agree that there is something that needed to be done after Brown. But you now have the opportunity to fine-tune that and make sure you don't have these unintended consequences. I just implore you to do that.
All right. I think that's it for time. Thanks.
Yes. Thank you, Ms. Dillon. Next, we'll go to Monsieur Fortin for 2.5 minutes.
Merci, Monsieur le
Thank you, Mr. Chairman. I have 2 minutes, so I'll take a slightly different point of view. In June of last year, Professor Parent de l'Université de Montréal said that the concept needed to be broadened because limiting the defense to cases of extreme intoxication would prevent the court from taking into account other kinds of intoxication, which may not be extreme, but which disconnect the person from reality, like some states of psychosis. Should Mr. Parent be concerned that extreme intoxication, as defined here, is too limited to take into account cases where the accused might invoke the absence of mens rea, as in cases of psychosis, for example?
Well, it seems to me that extreme intoxication will be available for drug-induced psychosis, from what I can tell. I'm not sure. Am I answering your question?
Le professeur Parent, Hugues.
Professor Hugues Parent, and I'll quote him, was saying this: in limiting extreme intoxication to a state that appears like automatism, the government leaves aside forms of intoxication that do not disrupt the consciousness of the individual, but disrupt the individual's connection with reality. For example, forms of psychosis. I'd like to hear your view on that. Ms. Sheehy, perhaps? We have some 20 seconds left.
I'm sorry, I guess I don't understand the context of his remarks. Is he suggesting that the new legislation is too narrow, or our understanding of the defense of extreme intoxication is too narrow?
The definition of extreme intoxication is too narrow. That's what he's saying. He is wondering whether it should be broadened to take into account other types of intoxication, which may not be extreme, but does lead the individual to lose touch with reality.
Right. Well, as I guess I can only repeat what I said, which is I believe that drug-induced psychosis, because it does involve a break from reality, has the potential to be part of an extreme intoxication, the basis for an extreme intoxication defense. So I think that the case law may be evolving to accommodate his concern that it's too narrow.
Thank you. Thank you, Monsieur Fortin. Mr. Garrison for 2.5 minutes.
Thank you, Mr. Chair. 2.5 minutes obviously is very short. So on the question of the impact on charging, if we fine-tune this with any of the three options that Professor Grant has suggested to us today, will that have an impact on the potential reduction of the number of charges who were laid? I guess Professor Grant would be the logical one to have to answer that.
I believe she had to leave.
She had
so
to leave?
left.
Perhaps either one of you two then.
Well, I think the hope would be that it would, that any of those amendments would change the worrisome specter of prosecutions being dropped. I mean, this is not an exact science, obviously. Drafting legislation and expecting to produce particular results. But I think it's fair to assume that a change in the legal standard, as explained in the legislation, would have an impact on prosecutorial decisions.
And I know the expertise that you have before us is constitutional law, but I guess I have a question about whether there could be a way prosecutorial guidelines could be used both in terms of extreme intoxication cases, but also just in sexual assault cases more broadly to ensure that more charges are laid.
Yes, well, but some of this is a policing issue. As you know, we have a very widespread and profound and persistent problem of police unfounding of sexual assault in Canada, and the rates in some jurisdictions remain very high. So, prosecutorial guidelines won't change that for those provinces that use police as their charging decision makers. Prosecutorial guidelines, yes, can be helpful. I imagine most provinces actually have prosecutorial guidelines on sexual assault. And I'm sure that some provinces will be issuing ones that include extreme intoxication as part of their effort to guide Crowns in making their decisions in these cases.
Great, thank you. I'm sure there's nothing meaningful left in time, so thanks very much.
Thank you, Mr. Garrison, and thank you to the witnesses, Professor Sheehy, Professor Frock, and Professor Grant, who's had to leave just shortly. This concludes our first round. We'll just take a minute to suspend and get our next witness on board, and then we'll go, just for the sake of members, we'll be going to about 5:40. So we'll be a slightly shorter round, but we only have one witness. So thank you. I'll just suspend shortly. second panel consists of Ms. Suzanne Zakour of the National Association of Women and the Law. Ms. Zakour, you can speak for 5 minutes, and then we'll begin our round of questions.
Thank you. Hi, everyone. My name is Suzanne Zakour, and I'm the head of Feminist Law Reform at NAL, the National Association of Women in the Law, l'Association Nationale Femmes et Droits. NAL is a national not-for-profit organization that advocates for women's rights in Canada, and we've been doing this work since 1974 and have consulted many times with many governments on the development of legislation that protects women's rights, including major reforms of sexual assault law in the 80s and the 90s. The National Association of Women and the Law has 3 major concerns regarding this bill. First, we need to consider all impacts of the law, not just its impact on acquittals. So even if an accused does not have a valid defense, he can still claim extreme intoxication to influence the victim, the police, and prosecutors in their decision to report, charge, and plea bargain. I probably don't have to remind you that most sexual assault and domestic violence cases never make it to trial. So it's really important to consider the law's impact before the court process. We're particularly concerned about cases not being brought forward because the accused was drunk. So to make things really clear to victims, to police, to prosecutors, we have recommended that the law explicitly state that alcohol is presumed not to cause extreme intoxication. Also, adequate training and public information will be necessary. Second, we are concerned about the Crown's ability to prove marked departure, given the bill's mention of the foreseeability of both the risk of extreme intoxication and the risk of harm. So will the use of any street drug just guarantee the success of the defense because there's no way to know what's in there? Or will an accused who has taken these drugs before say it wasn't foreseeable because I've done this before and didn't lose control? Or will an accused that has not taken these drugs before say the same thing? I've never done these drugs before, so how was it foreseeable that my body would react in this way? Will a man who regularly assaults his wife while drunk say that losing control on that particular occasion wasn't foreseeable because he's an habitual drinker and he has never reached extreme intoxication before? The courts, but also police and prosecutors, must receive proper guidance on these issues. Our third point is that we need a commitment to reviewing the law after these hearings and documenting the use of the defense, because a lot of the conversation around this bill has been about how this defense is allegedly very rare. That's what we keep hearing. But how could we know that if most accused have been completely barred from raising the defense for the past 27 years? You've heard research presented by Professor Sheehy in the previous panel, which suggests that extreme intoxication defense could be used more regularly than anticipated. And as was made clear, we don't know what the impact will be of this defense outside of the trial, for example, in charging decisions. So the bill has now passed. How are we going to find out if the defense is indeed rare and working as intended, or if it becomes the new cover-up for drunk violence against women? Are repeat abusers using the defense? Does it succeed when alcohol alone is involved? Or are the courts strict or permissive? We need answers to those questions. So we ask that your committee recommend a 3-year review of the law. I'm speaking with you today at a time when it's too late to amend the provisions, but there's still time to get this issue right. So I thank you for listening, and thank you for giving this issue the consideration that it deserves.
Thank you. I believe I have Mr. Caputo, or would it be you, Mr. Brock, first? Mr. Brock for 6 minutes.
Thank you, Chair. And thank you, Ms. Zakour, for your presentation today. I have a few questions for you. I'm going to give you an opportunity right from the outset. Is there anything that you want to expand upon with those three key suggestions that you finished off with in terms of how this bill can be approved?
Absolutely. Thank you for the opportunity. I want to maybe add something more on the use of alcohol alone to cause extreme intoxication. There has been mention of the fact that it is doubtful on a scientific level that alcohol alone can cause extreme intoxication. However, for the law to cause damage, you only need one expert to say, yes, it happens, and you don't even need that. You only need one police officer or one prosecutor or one victim to think that an expert could say that. So we really want to emphasize our organization that it's not just how the law is designed to work, but how it will actually work in practice that should receive really proper consideration.
Which probably explains why there's an emphasis in your mind that a 3-year review would be warranted in the circumstances. We're wading into new territory right now, and given the lack of meaningful consultation with numerous groups across this country, we can all agree that this was hastily put together, this particular piece of legislation. There was no urgency. There was a requirement for the government to react, but there wasn't that pressing urgency by which we have the bill that is now before us. So I appreciate your commentary, and I really appreciate your first point about the impacts of the law. I'm a former prosecutor. I had 30 years of prosecutorial experience, and I prosecuted a number of offenses involving women as the victims, sexual assault, aggravated assault, where these types of defenses came up. I only had one successful one case where I actually lost to a Section 33.1 defense, but I'm aware of the overall impact that it has for victims. Given the vagueness by which this legislation has now been drafted, I foresee the availability of this defense to open up much more litigation that we have currently seen. And inherently with that, that means that more victims are going to be traumatized by the length of time by which these defenses are going to be drawn out in courts. Do you share that concern in terms of the delay issue and the overall impacts to victims?
Absolutely. And I want to emphasize the fact that the law that I learned in law school is really different from what I hear from victims. I've heard from victims, they said they're not pressing charges because the crime is, there's a limitation, it's prescribed, which of course doesn't make sense for sexual assault. I have victims said they're not going to press charges because there was no penetration, which also doesn't make sense with the state of the law. So it's really important to consider that the law is not always applied in this very sophisticated way, and the way that the Supreme Court applies the law is not the same way that police officers or prosecutors across the country will necessarily apply the law.
And another concern that I have is the issue regarding alcohol as being the sole intoxicating substance. I seem to recall long before the Supreme Court of Canada issued the Brown decision that the jurisprudence made it abundantly clear to prosecutors, particularly in Ontario, that alcohol alone would never succeed in a defense under Section 33.1. Now, with this new legislation and some of the reports I'm reading from some of the professors who testified before you, it would appear that alcohol is indeed open to that type of consideration. Would you agree with that?
Yes, the discourse that we have heard from the Supreme Court and from commentators is that alcohol is unlikely to lead to extreme intoxication, that means that as soon as someone proves that there was extreme intoxication, there's no way to prove the foreseeability. Everyone is saying it's not foreseeable that alcohol would lead to extreme intoxication. The other issue is that NOL has consistently advocated for judicial training, and this is something that there's been some progress on, but it's something that continues to be of concern because, again, just because an academic says something in an article or the Supreme Court even says something doesn't mean that it will reach all judges and that it will be applied consistently.
And that's the problem, because judges will see things much differently. There often is not that consistency that one would expect, particularly in this area of the law. And I think that's why the professor is really stressed on tightening up, ultimately, the legislation to make it abundantly clear what authority the judges have in these circumstances.
The more the law is clear, obviously, the better for everyone. We shouldn't trust that people will just know all the jurisprudence very well. The law should be very clear and easy to interpret, in my opinion.
You also,
Thank you.
I believe, my time's up?
Yes.
All right, thank you, Chair. Thank you.
Next, for 6 minutes, Mr. Naqvi, please.
Thank you very much. Thank you for appearing, and I also want to thank the witnesses that were before us earlier. I'm going to ask some few questions because I'm a bit confused, and so I'll just and I was talking to Professor Dr. Frog earlier as well, just to alleviate my confusion and better understand. So let's just start with some really basic thoughts of yours on the defense and the law that we're speaking of. Did you agree with the defense under 33.1 that existed before it was struck down by the Supreme Court of Canada?
You mean, did I think it was a good policy choice, or did I think it was constitutional?
Did you answer both? That's good. That's a good question. Tell me about both. Yeah.
I know that NOL, our organization, was involved in pushing for this legislation, so it's definitely something that we believed should be addressed, and that the defense of extreme intoxication shouldn't just be available without safeguards. Obviously, the Supreme Court of Canada has ruled this provision to be unconstitutional, so it's obviously not an option to go back there, but as Professor Frog has explained, doesn't mean that there are no other options on the table.
And what was your reaction to the Supreme Court of Canada's decision in the Brown case? Did you agree with the analysis? Do you agree with the decision, or you have concerns about the court's reasoning dealing with the previous 33.1?
We believe that women's rights and interests could have received more consideration. I also want to add that it's not a complete surprise. There has been commentary for a while saying that these provisions might be unconstitutional, and obviously the litigation doesn't get from someone raises the constitutionality to the Supreme Court releases a decision in a day. There are often many years that go through. So this was, might I say, reasonably foreseeable that we could have been put in this situation. So that's why NOL's primary concern, or one of the things we've been most vocal about, is why haven't the consultations taken place even before? If there was such a need to act so quickly, which is hard to understand given the minister's insistence that the defense is so rarely used, but if it was a need to act so quickly, then why weren't these consultations started much earlier with the women's groups?
Okay, I mean, I've heard that argument before. I don't know if one could presuppose a Supreme Court decision and be ready for all eventualities at all times. So just, I don't agree with that thought process 100%, but that's just my opinion. But don't you think, in the fact that the Supreme Court decision came, that there was a gap, there was a vacuum that needed to be addressed as quickly as possible in order to protect women? I mean, that position that all parliamentarians took by fast-tracking drafting and passage of the legislation, in your view, was not an appropriate way to move forward? Should we had delayed it? And would that have been a good public policy?
Well, I think it's one way or another. Either, it's such a rare defense that it doesn't matter that the standard is very high for the Crown because it's such a rare defense, never comes up, hasn't come up since the Brown decision, or this is a very urgent matter on which there's no time to even have these hearings that we're having today. So I don't think it is fair to women's groups who have been instrumental in working towards just even getting our basic sexual assault provisions in the criminal code to rush these consultations. As Professor Fruck explained, we felt that the way we were consulted was a little bit after the fact. And I don't want to presume of the intention for these consultations, but definitely we feel that, a couple more weeks to make sure it's better done would have been preferable. It also depends if you're going to get away from this committee and then make amendments to the law, or if we're being heard after the fact to kind of, there have now been consultations, but we want meaningful consultations. So it's just not just us talking at you. We actually want our concerns to be ideally integrated in the lawmaking process.
I appreciate that. I thank you for that. I also heard in your remarks you're concerned you're concerned with the law, of course, but most also critically about the application of the law. Am I correct that a lot of the women's group, the bigger concern is that the law may be good or perfect, but how it's applied by the police, by the prosecutors, by the judges is a bigger concern because its applicability has not been across the country, has been identical or the same. Is that that's a big issue for your organization? And
yes, and I, as a sexual assault law scholar, I can say application is always our biggest concern. I wouldn't say that the law is perfect. The problem is application. We have concerns with the law, but we believe that the law is feeding and giving possibilities for the application to be even worse because of the lack of clarity.
But so a lot of the conversation in our earlier panel was around subsection 2 and whether there should be a standard or not. And this is where I'm getting a little concerned and confused because I think by providing for a standard in subsection 2 will allow for more uniform application of the law versus the absence of the standard where different judges, different prosecutors, different police officers may interpret the law differently.
Very briefly,
Can I
Mr.
answer? Well, the problem with it's not a standard, as Professor Grant explained, the standard is marked departure. What is given in the subsection that we're criticizing is factors. So it's always the question, why these two factors? What were all the other factors that you decided not to include in the law and why? And how are these factors to be weighed? So that's what we think will lead to inconsistent and problematic application.
Thank you very much.
Thank you.
Thank you, Mr. Naqvi. Over to you, Mr. Fortin, for 6 minutes.
Merci, Monsieur.
Thank you, Mr. Chairman, and thank you, Ms. Acourt, for being here today. I understand that you're saying that you weren't consulted by the minister before these provisions were passed. I'd like to know what you would have said to the minister if you had been consulted before the legislation actually went through. I think what's been said today is what we would have said then, ensuring that the standard be provable for the Crown and also that criteria included needed to be clear and relevant. Someone who becomes intoxicated knowing there is a risk that he or she may cause harm, that is irresponsible. Somebody who becomes intoxicated when there is a risk of losing control of their actions is also irresponsible. Do we really need both, like Professor Grant said? I think that we would have pushed for legislation that was far more clear, and we've been critical from the beginning of the need to prove that there is a foreseeable risk of harm. If I look at paragraph 2 the court must take into account the objective foreseeability of the risk. We are already there. We're already looking at something that's rare, and every condition makes the risk even more rare. So there needs to be proof that intoxication was foreseeable, that the intoxicating substances that the person would be taking, it came with an objective foreseeability that the person could become extremely intoxicated. So we're talking, if I get this right, about things that are very unusual and rare. Well, that's the major issue. It depends on the level of risk that we're looking at, and that is not clear in the legislation, in my view. So do we need to prove that it could happen, that there was potential? Do we need to prove that it is likely or plausible? That is where the legislation could be interpreted differently. A judge might say, well, when you get intoxicated, there's always a risk that you may lose control. Another judge might say, most people who become intoxicated do not become violent. And certainly people who are violent can be violent without becoming extremely intoxicated. This is why I recommend that we look carefully at how this legislation ends up being interpreted. Because the guidance proposed in the legislation to help courts might end up obscuring more than they clarify. If you had to draft subsection 2, what in it would you change? Now, I'm not talking about eliminating it altogether. If you had to rewrite it, what would you do? Well, I do think that eliminating it is something you heard Professor Grant support, and it is certainly an interesting proposal. If it had to be rewritten, as I was saying, well, if there's a risk of a person becoming violent, if there's a risk of a person's losing control of their actions, I believe that either is individually sufficient to hold someone responsible for their actions. I gave an example of a spouse who's violent against his wife when he drinks, so it's predictable that he'll become violent when he drinks, but it's not foreseeable that he'll become extremely intoxicated because he's violent even when he is not extremely intoxicated. That's where I believe the double standard is excessive. I would also have recommended to clarify the standard. If we are not to let the courts assess what is reasonable, if there is, and assess the presence of a marked departure, then we have to look at the level of risk. Are we talking about possible, likely, probable?
Mais n'êtes-vous pas d'accord pour dire...
But would you not agree? I know there is case law on this, but would you not agree that any person who consumes an intoxicating substance or intoxicating substances to the point of becoming extremely intoxicated, would you not agree that objectively there is necessarily a risk once you've consumed enough to become extremely intoxicated? Is there not a risk that you will be extremely intoxicated and therefore a risk that you will harm someone? Not that you necessarily will, but that there is a risk that you will. Objectively speaking, when you consume, well, I don't know how much it takes, but I think you need to consume a lot before becoming extremely intoxicated. Is the harm or potential of harm then not foreseeable? Well, what's been said is that many people who become intoxicated don't necessarily know exactly how much they're having or even what exactly they're having. So do you become extremely intoxicated, and what does it take? How many drinks does it take? Obviously, somebody who puts him or herself into that situation, well, as people who defend the rights of women, we're always concerned about people who lose control of their actions and the potential for harm against women or other people around them. Thank you.
Over to you for the last round.
Thank you very much, Ms. Kaur. I know you did say sort of offhand another couple of weeks, and I have to respond to the parliamentarian that in parliamentary terms, another couple of weeks would have meant missing the spring session completely, and we would have been here this fall at this time trying to deal with this. So I know that's sometimes hard for people to contemplate, but for Parliament to move as fast as we did was a minor miracle. But if we hadn't at that point, we'd likely be here now, and we're in a minority Parliament. And so we also risk the instability of a minority Parliament not getting to act at all. So I think there's a greater risk sometimes than's generally understood if we had not acted. And I guess that leads to my question, again, on the question of whether there was or still is a vacuum to fill. And I think I know your answer, but I'd like you to address that directly.
Thank you. And if I could, I'll just maybe react to the first part of the preamble to your question that had a preamble contrary to the law, which we advocated for it to have a preamble. But I guess the question I can send back to you is, were we useful today? How useful were we? And I say we, Noel and the law professors you heard previously. Was it worth the delay? That's a question you can answer because you've been listening. And I do recognize the difficulty in getting this machine to work as fast. And we're certainly hoping, we're advocating on a lot of issues. And I can tell you that for many women, their concern and the most harm and violence they receive is not addressed by this action. So we would like to see this commitment in other issues, which I know you believe in too. So, and I forgot the actual question. I only answered the preamble.
Do we still have a vacuum?
Yes. Okay. So we believe that it is still worth taking the time. Now that perhaps the dust has settled, and I know that misinformation was a concern for the Parliament, so we believe there's still good reason to amend the law and to close a gap, but also clarify and just make the law easier to apply.
I know at the time we had our discussions, I think holding these hearings, there was a gesture of good faith that it wasn't just for the sake of holding hearings, but if we need to make further adjustments, that these hearings would inform us about that and provide that possibility.
We certainly hope so.
So I'm sometimes viewed as overly optimistic, but I've only been in Parliament 11 years. So sometimes I've seen us do the right thing. My question, very last specific question, because I know we're running out of time here, is on the standard of foreseeable harm versus loss of control, which was very, very clear in the previous panel. Would you see it useful for us, if we weren't going to eliminate that section, to rewrite it so the focus was on the foreseeability of loss of control rather than harm?
Well, certainly the argument can be made that if it's foreseeable that you're going to lose control, if we believe the necessity for this defense and the whole premise is that when you lose control, you lose control. There is no telling what you're going to do. So then it seems sufficient to hold someone responsible if the intoxication was voluntary. Perhaps one or the other could also be sufficient. But certainly we feel that having to prove that beyond a reasonable doubt, with the concerns that we have regarding how courts will interpret, like, who is this reasonable person, and what kind of risks do they take in a society where most of these intoxicants are illegal, but then people still take it. Like, what does the reasonable person do in these circumstances? These are very difficult questions, and the courts have not always seen eye to eye with the women's organizations in what is reasonable, what kind of risk is reasonable to place women in.
Thanks very much, and I do take seriously what both you said, the other panel, and the Native Women's Association of Canada, that there's many other aspects surrounding this where we need better supports, better education, and I know that we will all take those suggestions seriously in our future work. So thanks very much.
Thank you, Mr. Garrison. I want to thank the witness, Ms. Zakour, for a very informative session and informing us, and I want to thank all our members. Before I suspend, I just want to remind them, members, that for the November 3rd Thursday meeting, if there's any witnesses you haven't sent in, to send them in. Currently, we have 3 confirmed, so just have your whips, please look into that if there's any witnesses that need to be informed. Other than that, I'll conclude and thank you very much for having a successful meeting.